Hello, and thanks for watching our presentation on why most estate plans fail and what to do about it. This presentation is brought to you by Joseph L. Moda. This presentation will look at why traditional estate planning exposes your family to unnecessary risks. We'll look at the issues that most estate plans fail to address and explore how to protect your family even after your death.
We are in a new era of estate planning because of several factors, including the risks to your family and assets from divorcing spouses, lawsuits, and other creditors, the frequent occurrence of second marriages in which each spouse has children from their prior marriage, and the desire of most people to avoid the costs and delays associated with the probate process.
In today's world, your family's assets are exposed to significant risks that the typical estate plan fails to address. Most estate plans are comprised of what are referred to as mom and pop or sweetheart wills, where each spouse leaves everything to the other, and upon the death of the second spouse, everything is divided equally among the children. Let's look at this graphically. Upon the death of the husband, all of his assets are transferred to the wife. Upon her death, their combined assets are passed along to the children. Let's look at a case study and see how this plays out in the real world. Bill has $500,000 in assets, and Mary has accumulated $300,000. Bill and Mary have two children, Jim and Judy. So looking again at the distribution of assets with a traditional estate plan, we see Bill's $500,000 go to Mary upon his demise, that combined $800,000 going to Jim and Judy upon hers. So what are the problems with this typical estate plan? Well, number one is probate. Probate is the legal process through which title to assets owned by a deceased person is transferred to his or her heirs. The entire process is supervised by the probate court. And the probate process includes an inventory of all assets, many of which must be professionally appraised. It requires a notification of all potential heirs. It's expensive and requires an attorney, with court costs and attorney fees generally 5% or more of assets. It's time-consuming, generally 6 to 18 months, and it's public. Anyone can inspect probate court records at any time and find out what was left behind for your heirs. When you have an estate transferred by will, it is necessary to go through the probate process. In our example, there would be two probate proceedings. First, upon the death of Bill, and again upon the death of Mary. Another concern is that a basic estate plan makes no provisions for problems that may occur prior to death. For example, if Bill suffers a stroke, becomes incapacitated, and is unable to manage his affairs, Bill and Mary must endure the costs and burdens of what's called living probate. Mary must hire an attorney and go to probate court to be appointed guardian of Bill's property. She must provide periodic accountings to the probate court and disclose how she has managed Bill's assets. The court is in control. It is time-consuming and expensive when you include the court fees, attorney fees, and accounting fees. A typical estate plan also fails to protect your family against problems that may occur after death as well. Number one is remarriage. The basic estate plan provides no protection against the risks associated with the remarriage of the surviving spouse. For example, 5 years after Bill's death, Mary remarries. Her new husband convinces her to draft a new will, leaving all of her assets to him. Jim and Judy have now been disinherited. Even in a case where Mary's will leaves everything to her children, if Mary dies first, her new husband can elect to take against her will and acquire 1/3 of her assets legally. Mary's children still lose a substantial portion of their inheritance. The typical estate plan can also lead to problems for your children after your death. So let's say that the son Jim receives his inheritance, but is divorced a few years later. Because of the divorce, he can lose half of his inheritance to his ex-spouse. Or, another example, 2 years after receiving his inheritance, Jim dies leaving everything to his wife. His wife later remarries. And if she dies, the money she received from Jim will go to her new husband and the children of her new marriage. The assets have been transferred out of Bill and Mary's family line completely. Let's look at legal claims. Let's say Judy is involved in a major automobile accident and is subject to a large lawsuit. All of her inheritance may be used to satisfy a legal judgment obtained against her by a personal injury attorney. Or if Jim receives his inheritance and later files for bankruptcy, all of his inheritance is subject to the claims of his creditors and is lost. Let's say that Judy receives her inheritance and decides to embark on a 3-year shopping spree. All of her inheritance is lost through wasteful spending. And the basic estate plan provides no protection for special needs beneficiaries. Let's say that Jim is disabled and receiving government benefits. Upon receipt of his inheritance, his ownership of the assets will disqualify him from receiving any further government benefits. So in summary, the problems with a typical estate plan is that it requires probate court administration, does not protect against living probate or against remarriage, and does not protect beneficiaries from creditors and ex-spouses, and does not protect special needs beneficiaries. The good news is there is a better way. The problems with a typical estate plan can be avoided by using a properly drafted living trust. The document is called a living trust because it takes effect during your lifetime. The trust can be amended and revoked. A trust which is created by a will and becomes effective at death is known as a testamentary trust. Testamentary trusts are to be avoided because they require probate court supervision. So what is a trust? Well, a trust is a legal agreement in which title to property is held by one or more persons for the benefit of others. The person who creates the trust is known as the trustor, settlor, or grantor. The person who holds legal title to the property is the trustee. The person for whose benefit the property is held are the beneficiaries. So to look at it graphically, the grantor creates the trust and transfers assets to it. The trustee holds title to those assets and manages them for the beneficiaries who receive the benefit of the assets. Let's go back to our case study with Bill and Mary. They create a living trust and transfer assets to it. The grantors are Bill and Mary. They are the trustees. They are also the beneficiaries throughout their lifetime. As we see, they initially occupy all 3 positions. So what has this accomplished? Well, Bill and Mary now own title to their assets as trustees and not in their individual names. So when either of them dies, legal title will remain vested in the remaining trustee, and there will be no need for probate. If one or both of them become incapacitated, there will be no living probate, because the co-trustee will have authority to manage their property. So how does it impact day-to-day life? It's business as usual. You maintain complete control over assets, can still buy, sell, or refinance property, and there's no separate tax filings required. And most importantly, it can be amended or revoked if circumstances change. So let's see how a family trust avoids the problems associated with a typical estate plan. Again, Bill has a stroke or is incapacitated. Because Mary is a co-trustee under the trust agreement, she has the authority to manage all of Bill's property that was transferred to the trust. There's no need for her to apply to probate court to be appointed guardian of Bill's property. And living trusts are not just for married couples. A trust can provide the same benefits to a single person. If a single grantor becomes incapacitated, the trust agreement will name a successor trustee to manage assets for his or her benefit. This could be a daughter or another trusted individual of his or her choosing. It will not be necessary to go to probate court to be appointed guardian of the incapacitated person's property. In addition, all of the post-death benefits of a trust apply to singles as well as couples. Going back then to our example with Bill and Mary, when Bill passes away, there's no probate because legal title to the assets in the trust remains with Mary
The surviving trustee. The trust will also provide clear directions for the allocation and distribution of the assets of the deceased spouse.
The trust offers a great deal of flexibility in providing for the allocation of the deceased spouse's assets. Although there are many ways trust assets can be allocated, for the sake of example, we will show two of the most commonly used distribution provisions. Option 1 is designed to give the surviving spouse control over the assets of the deceased spouse. Option 1 is often used with a couple who have been married for a long time and whose primary goal is to provide for the well-being of the surviving spouse rather than to ensure an inheritance for the children. The deceased spouse's assets, together with the assets of the surviving spouse, are allocated to a trust for the benefit of the surviving spouse, which is basically a continuation of the original living trust. The surviving spouse will remain as trustee and beneficiary and have complete access to the trust's income and principal. In addition, the surviving spouse retains the ability to amend or revoke the trust. Option 2 is designed to protect the inheritance of the children. Option 2 is frequently used when the couple believes that the surviving spouse's assets are sufficient for the surviving spouse to live comfortably, and that they want to ensure the deceased spouse's assets are preserved for the children. Option 2 provides the children with protection from the remarriage of the surviving spouse or the surviving spouse's irresponsible use of the deceased spouse's assets. The assets of the surviving spouse are allocated to the survivor's trust. The surviving spouse will remain as trustee and beneficiary and have complete access to the income and principal of the survivor's trust. In addition, the surviving spouse retains the ability to amend or revoke the trust. The assets of the deceased spouse are allocated to the family trust. The family trust is an irrevocable trust, and the surviving spouse does not have the ability to amend or revoke the family trust. Often, the family trust is structured so that the surviving spouse serves as trustee and is entitled to receive the income generated from the trust for the remainder of his or her lifetime. However, the surviving spouse may have little or no access to the principal of the family trust. If a couple wanted to provide additional protection upon the death of the first spouse, they could have designated someone other than the surviving spouse to serve as trustee of the family trust and reserved both the income and principal of the family trust for the children. Accordingly, in our example, Bill and Mary could have provided in the original trust agreement that, upon Bill's death, his brother would serve as trustee of the family trust, and that Mary would not be entitled to the income of the family trust. So if Mary remarries, the children are protected. The trust does not allow Mary to control the disposition of the assets in the family trust. Jim and Judy cannot be disinherited. When Mary passes away, the assets in Mary's survivor's trust are combined with the family trust for the benefit of Jim and Judy. And no probate is necessary because legal title to the assets remains in the name of the trustee, even though it's a successor trustee who was named in the original trust agreement to manage the assets after Bill and Mary's death. Now, because Jim and Judy's inheritance is held in the family trust, we can also protect them from some common risk scenarios. If the trust is drafted to include special beneficiary protection language, we can shelter Jim and Judy from some of the uncertainties of life. Protection like this would not be available if the assets were distributed to Jim and Judy outright at the time of Mary's death, or if the trust agreement did not contain these special provisions. For example, a properly drafted trust can shield the beneficiaries from legal judgments and other creditor claims. What this means is that the assets in the trust can be protected from lawsuits and from personal injury attorneys in the case of an accident. If Jim or Judy is divorced, their ex-spouse will not be entitled to any of the assets held in trust for their benefit. If Jim or Judy is forced to file bankruptcy, the assets held in trust for their benefit will not become part of the bankruptcy estate and will not be available to creditors. Even if Jim or Judy has a spending problem, the trustee can control the distribution of funds from the trust to ensure their inheritance is not squandered. If a beneficiary engages in irresponsible behavior, we can make distributions dependent upon being employed, staying in school, and remaining drug and alcohol free. And there's also protection for special needs beneficiaries. If a beneficiary has special needs and is receiving government benefits, an outright distribution will likely cause them to exceed the maximum amount of assets permitted to qualify for such benefits. However, if the assets are held in a carefully drafted special needs trust, the beneficiary will continue to qualify for those benefits. So let's review the advantages of using a trust. It avoids probate court administration at death. It avoids living probate in the case of incapacity. It protects against remarriage of the surviving spouse. It protects beneficiaries from creditors and ex-spouses. It prevents distributions to irresponsible beneficiaries. And it also protects special needs beneficiaries. And we'd like to show you one of the additional planning opportunities available through the use of a trust. An IRA or other qualified retirement account is often one of the largest assets in a person's estate. Through proper planning, the assets in an IRA account can be used to generate substantial income for beneficiaries over the course of their lifetimes. Let's look at an example. Bill has an IRA worth $300,000. He's named Mary as the beneficiary of his IRA. At Bill's death, Mary can roll the assets of Bill's IRA into her own IRA account without incurring any taxes. Only the surviving spouse is permitted to do this. At the time of Mary's death, her IRA has a value now of $500,000. Mary has named Jim as one-half beneficiary and Judy as one-half beneficiary of her IRA. So the most common way is the wrong way. Upon Mary's death, Jim and Judy are delighted to have received this windfall, and each of them receives a distribution of $250,000 from Mary's IRA. But what about the taxes? The distributions received by Jim and Judy are fully taxable as ordinary income. The receipt of $250,000 would put Jim and Judy in the 33% tax bracket. This means that after income tax, the net amount received for each is $167,500. So are there better options? Well, under IRS rules, those who inherit IRAs must take distributions of the entire amount one of two ways, either over a period of 5 years from the IRA owner's death, or over the beneficiary's remaining life expectancy, based on tables published by the IRS. This is what we call the stretch. Taking distributions over the beneficiary's life expectancy is a much better option because it allows the funds of the inherited IRA to continue to earn income on a tax-deferred basis, providing the beneficiary with much greater distributions over the course of his or her life. So how does it work? Well, at the time of Mary's death, Jim is 45, let's say, and Judy is 42. According to the IRS tables, Jim's remaining life expectancy is 38.8 years, Judy's is 41.7. Assuming a 5% rate of return, with Jim and Judy in the 25% tax bracket, by taking the required minimum distributions over his remaining life expectancy, Jim will receive, after taxes, $586,891. By taking the RMDs over her remaining life expectancy, Judy will receive, after taxes, $645,087. However, just by naming Jim and Judy as the beneficiaries of her IRA, Mary cannot require them to take advantage of the stretch. Unfortunately, most IRA beneficiaries just can't resist the urge to take a large lump sum distribution upon the IRA owner's death. But Mary can require Jim and Judy to take advantage of the stretch by creating a special IRA Beneficiary Trust. Mary can name the trust as the beneficiary of her IRA rather than Jim and Judy individually. The trust will require the trustee to withdraw and distribute no more than the required minimum distributions over Jim and Judy's lives. Through the use of an IRA Beneficiary Trust, Jim and Judy can receive a steady stream of income for the remainder of their lives. So as you've seen, a proper estate plan not only provides for the efficient distribution of your assets to your heirs, it allows you to protect your family in the event of your incapacity and after your death. For a free consultation, to learn more about how you can protect your family, call Joseph Moda at 440-930-2826 and schedule a free personal consultation. And thank you for watching this presentation. We hope you found it informative, and we look forward to seeing you soon.